Question 1. During an emergency response where multiple areas are impacted, the federal government issues a temporary executive order restricting the publication of certain classified military documents that have been leaked to a news organization. The order cites concerns that the publication could compromise national security and endanger lives. The news organization argues that this constitutes unconstitutional prior restraint. Under established First Amendment jurisprudence, how should a court analyze this issue? A. The government may impose prior restraint whenever it determines that national security concerns are at risk, as courts must defer to executive judgment in such matters. B. Prior restraint is generally unconstitutional, but the government can justify it if it meets a high burden of proof showing that publication would cause direct, immediate, and irreparable harm to national security. C. Courts should allow prior restraint only if the government proved that the publication is false or misleading and could lead to public panic. D. The press has an absolute right to publish any information it obtains, and any governmental restriction is automatically unconstitutional under the First Amendment. Answer. B. Prior restraint is generally unconstitutional, but the government can justify it if it meets a high burden of proof showing that publication would cause direct, immediate, and irreparable harm to national security. Explanation. This question references the landmark Supreme Court case New York Times Company v. United States, 1971, also known as the Pentagon Papers case. The court ruled that prior restraint presumptively unconstitutional, and the government carries the heavy burden of proving that publication would result in direct, immediate, and irreparable harm to national security. A is incorrect because courts do not defer automatically to executive judgment. Instead, they apply strict scrutiny to restrictions on press freedom. C is incorrect because prior restraint does not hinge on whether the information is false or misleading, but rather on the extent of harm its publication would cause. D is incorrect because press freedom, while broad, is not absolute. In extreme cases, courts may permit limited restrictions if government meets the strict scrutiny standard. Question 2. In a situation where formal requirements conflict with religious beliefs, a state law requires all employers to provide health insurance plans that include coverage for contraceptives. A religious nonprofit organization challenges the law, arguing that it violates the free exercise clause of the First Amendment. The state argues that the law is neutral and generally applicable. Under Supreme Court precedent, how should the court rule? A. The law violates the free exercise clause because it forces religious organizations to act against their beliefs, requiring strict scrutiny review. B. The law is constitutional because it is neutral and generally applicable, meaning the government does not need to show a compelling interest. C. The law is unconstitutional because religious organizations have an absolute right to exemption from any law that conflicts with their beliefs. D. The law is valid under the Religious Freedom Restoration Act, which requires the government to accommodate religious exercise unless there is a compelling interest. Answer. B. The law is constitutional because it is neutral and generally applicable, meaning the government does not need to show a compelling interest. Explanation. This question is based on Employment Division v. Smith, 1990, in which the Supreme Court ruled that neutral and generally applicable laws do not violate the free exercise clause, even if they incidentally burden religious practice. A is incorrect because strict scrutiny applies only when the government targets religious practice rather than imposing a neutral law. C is incorrect because religious organizations are not automatically exempt from all generally applicable laws. D is incorrect because while RI requires accommodations in some situations, it applies at the federal level, and states are not necessarily bound by it unless they have their own RA statutes. Thus, fifth, the state law is likely constitutional as long as it applies equally to all employers without targeting religious groups. Question 3. While investigating a complicated issue between different online platforms and government regulations, Congress enacts a law requiring social media companies to remove certain categories of speech such as false political information under penalty of fines. A free speech advocacy group challenges the law, arguing that it violates the First Amendment. How should a court assess this case? A. The law is constitutional because private companies do not have First Amendment obligations, and the government can impose reasonable content regulations on digital platforms. B. The law is unconstitutional because it amounts to government-compelled censorship, which violates the content-based restriction doctrine under the First Amendment. C. The law is valid under forum analysis, as the government has the right to regulate speech on platforms that serve the public function. D. The law is constitutional because preventing the spread of false information is a compelling state interest that outweighs speech protections. Answer B. The law is unconstitutional because it amounts to government-compelled censorship, which violates the content-based restriction doctrine under the First Amendment. Explanation. This question tests students on government regulation of speech and the content-based restriction doctrine. Under Supreme Court precedent Rav v. St. Paul, 1992, content-based regulations of speech are presumptively unconstitutional unless they fall into a narrowly defined category of unprotected speech, e.g., incitement, obscenity, defamation. A is incorrect because while private companies are not bound by the First Amendment, government-imposed speech restrictions on private entities raise constitutional concerns. C is incorrect because forum analysis applies to government property, e.g., streets, parks, but not to private platforms like social media. D is incorrect because preventing false information while a government interest does not justify content-based censor unless it meets strict scrutiny. Since the law compels platforms to remove specific speech categories, it likely constitutes unconstitutional censorship under First Amendment jurisprudence. Question 4. During a critical transition period where existing processes are being re-evaluated, a city council passes a new ordinance requiring all individuals who wish to protest in a public park to obtain a permit at least 2 weeks in advance. The ordinance specifies that the permit will be granted unless the protest is deemed to pose a significant risk to public order. Several local activists challenged the ordinance, arguing it poses an unconstitutional restriction on their First Amendment rights. Which of the following is the most accurate legal analysis of this case? A. The ordinance is unconstitutional because requiring permit for protest in public forum is always an impermissible prior restraint on speech. B. The ordinance is likely constitutional because the government has broad discretion to regulate public assemblies based on concerns for public order and safety. C. The ordinance is unconstitutional because it fails to provide clear criteria for permit approval and thus risks being applied in arbitrary and discriminatory manner. D. The ordinance is likely constitutional as long as it is applied evenly to all groups and does not target specific viewpoints. Answer C. The ordinance is unconstitutional because it fails to provide clear criteria for permit approval and thus risks being applied in an arbitrary and discriminatory manner. Explanation. Under First Amendment jurisprudence, government restrictions on protests in public forums, such as parks, sidewalks, and streets, must comply with the time, place, and manner test. This means the restriction must be content neutral, not favoring, discriminating against specific viewpoints, narrowly tailored to serve a significant government interest, leave open ample alternative channels for communication while requiring a permit is not inherently unconstitutional. The ordinance in this case has vagueness and overbreadth issues because it grants officials the power to deny a permit based on subjective criteria. Whether protest poses a significant risk to public order. The lack of objective and clear standards creates risk of arbitrary enforcement, which courts have repeatedly struck down in cases such as Shuttlesworth v. City of Birmingham, 1969. If the ordinance granted officials unlimited discretion in approving or denying permits, it would likely be found unconstitutional. Answer choice is incorrect because permit requirements are sometimes allowed under the First Amendment provided they meet the time, place, and manner test. Answer choice B is incorrect because the government does not have unlimited discretion to regulate public assemblies. Answer choice D is incorrect because even content-neutral law must not allow arbitrary enforcement. Just because law applies to all groups does not mean it satisfies constitutional requirements. Question 5. In a high-stakes environment where multiple challenges arise due to rapidly evolving technology, a state legislature enacts a law prohibiting individuals from using social media to post false or misleading information about government policies. The law is challenged in court as violation of the First Amendment. Which of the following is the strongest constitutional argument against the law? A. The law is unconstitutional because the government cannot regulate speech in online spaces under any circumstances. B. The law is unconstitutional because it is vague and overbroad, failing to define what constitutes false or misleading information. C. The law is likely constitutional because preventing misinformation is compelling government interest that justifies regulation. D. The law is constitutional because social media companies, private entities, and the First Amendment does not apply to private actors. Answer. B. The law is unconstitutional because it is vague and overbroad, failing to define what constitutes a false or misleading information. Explanation: the law in question raises serious vagueness and overbreadth concerns under the First Amendment. In Grain v. City of Rockford, 1972, the Supreme Court held that laws restricting speech must provide clear guidelines to avoid arbitrary enforcement. The phrase "a false or misleading information" is subjective and does not establish clear standards for what speech is prohibited. Furthermore, in United States v. Alvarez, 2012, the Supreme Court struck down law criminalizing false statements about military honors, ruling that even false speech receives First Amendment protection unless it falls within specific category of unprotected speech such as fraud or defamation. Answer choice is incorrect because the government can regulate some speech online, such as threats or fraud. Answer choice C is incorrect because while misinformation may be concerned, the law's broad wording violates constitutional standards. Answer choice D is incorrect because although private companies are not bound by the First Amendment, this law is government-imposed restriction on speech. Question 6. While investigating a complicated issue between different stakeholders in the education system, a school district implements a new policy banning students from wearing any clothing that features political messages, including slogans, symbols, or logos related to social causes. A student challenges the policy, arguing that it violates their First Amendment rights. How should a court analyze this issue? A. The policy is constitutional because public schools have the authority to prohibit all forms of speech that could disrupt the learning environment. B. The policy is unconstitutional because it is overbroad and prohibits a wide range of speech without evidence of disruption. C. The policy is likely constitutional because students do not have First Amendment rights in public schools. D. The policy is unconstitutional because schools must allow students to express any viewpoint without restriction. Answer: B. The policy is unconstitutional because it is overbroad and prohibits a wide range of speech without evidence of disruption. Explanation: public school students do not lose their First Amendment rights at the schoolhouse gate as established in Tinker v. Des Moines Independent Community School District, 1969. However, schools may impose restrictions on student speech if it materially and substantially disrupts the educational environment. The blanket ban on all political messages is overbroad as it prohibits speech without requiring evidence of actual disruption. Answer choice is incorrect because schools must demonstrate a disruption to justify restricting speech. Answer choice C is incorrect because students do have First Amendment rights in public schools. Answer choice D is incorrect because while students have speech rights, schools can impose reasonable restrictions under Tinker. Question 7. During an emergency response where multiple areas are impacted, a state governor issues an executive order prohibiting journalists from publishing leaked government documents that contain classified information about disaster response strategies. A newspaper publishes the documents anyway and is sued by the state. How would the courts likely rule on this case? A. The lawsuit is unconstitutional because the government can never prevent publication of classified information. B. The lawsuit is likely unconstitutional because prior restraint on the press is only allowed in extreme cases, such as direct threats to national security. C. The lawsuit is likely constitutional because the government has an interest in preventing the spread of sensitive information during emergencies. D. The lawsuit is constitutional. Journalists have a duty to comply with state regulations regarding classified materials. Answer: B. The lawsuit is likely unconstitutional because prior restraint on the press is only allowed in extreme cases, such as direct threats to national security. Explanation: this case raises prior restraint issues under the First Amendment, which prohibits the government from preventing publication before it occurs except in extraordinary cases. The Supreme Court's decision in New York Times Company v. United States, 1907, Pentagon Papers case established that prior restraint is presumptively unconstitutional even when classified information is involved, unless there is an immediate, direct, and serious threat to national security. Answer choice is incorrect because while prior restraint is generally prohibited, there are rare exceptions, e.g. troop movements in wartime. Answer choice C is incorrect because the government's interest must be compelling and narrowly tailored. Vague concerns about disaster response are insufficient. Answer choice D is incorrect because journalists are not obligated to comply with government secrecy rules unless they personally signed confidentiality agreement. Question 8. Faced with an unprecedented situation that challenges traditional interpretations of the law, a state government passes a law requiring all social media companies operating within the state to verify users' identities before allowing them to post any content. The law is challenged in court on First Amendment grounds. Which of the following is the most likely outcome of this challenge? A. The law is unconstitutional because it imposes an undue burden on anonymous speech, which is protected under the First Amendment. B. The law is constitutional because the state has a legitimate interest in preventing online harassment and misinformation. C. The law is unconstitutional because only the federal government can regulate social media companies. D. The law is likely constitutional as long as it applies equally to all users, does not target specific viewpoints. Answer A. The law is unconstitutional because it imposes an undue burden on anonymous speech, which is protected under the First Amendment. Explanation. Anonymous speech is a well-established right under the First Amendment, as reaffirmed in McIntyre v. Ohio Elections Commission 1995. The Supreme Court has ruled that the right to anonymous free speech is protected because it encourages the free exchange of ideas, particularly controversial topics. While the government does have a legitimate interest in preventing online harassment and misinformation, answer choice B. The law is not narrowly tailored to achieve that goal. It broadly impacts all users, even those engaging in lawful speech. Answer choice C is incorrect because while federal regulations may preempt state laws in some cases, states do have some regulatory authority over businesses operating within their borders. Answer choice D is incorrect because even neutral laws must not impose an undue burden on speech, especially when anonymity is involved. Question 9. When examining a scenario where individual rights must be balanced against collective security concerns, a local police department installs high-resolution cameras on public streets to record all pedestrian and vehicular traffic. The footage is stored indefinitely and can be reviewed at any time without a warrant. A lawsuit challenges the policy on Fourth Amendment grounds. How should a court analyze this issue? A. The policy is unconstitutional because indefinite surveillance of public spaces without a warrant violates the reasonable expectation of privacy. B. The policy is constitutional because individuals have no expectation of privacy in public spaces. C. The policy is unconstitutional because only federal agencies, not local police, can conduct surveillance of this scope. D. The policy is likely constitutional if the footage is only when investigating a crime. Answer A. The policy is unconstitutional because indefinite surveillance of public spaces without a warrant violates the reasonable expectation of privacy. Explanation. While individuals generally have a reduced expectation of privacy in public places, the Supreme Court has ruled that long-term warrantless surveillance can still violate the Fourth Amendment. In Carpenter v. United States 2018, the court held that continuous location data without a warrant constitutes an unconstitutional search. The indefinite retention and review of footage without judicial oversight raises serious constitutional concerns. While short-term observation may not be a search under the Fourth Amendment, mass prolonged surveillance transforms public monitoring into an invasive tracking system. Answer choice B is incorrect because while privacy is diminished in public, surveillance practices must still comply with the Constitution. Answer choice C is incorrect because local police can conduct surveillance, but it must be done within constitutional limits. Answer choice D is incorrect because access restrictions do not change the fact that the surveillance itself is intrusive and warrantless. Question 10. In a rapidly evolving legal landscape where new technological developments outpace existing regulations, a federal agency issues a rule banning the use of facial recognition software in public spaces due to concerns over privacy and bias. A tech company challenges the rule, arguing that it violates their First and Fifth Amendment rights. What is the strongest legal argument the company could make? A. The rule is unconstitutional because it restricts the company's right to free expression through the development and use of technology. B. The rule is unconstitutional because it amounts to regulatory taking under the Fifth Amendment without just compensation. C. The rule is constitutional because the government has compelling interest in protecting privacy rights. D. The rule is unconstitutional because only Congress, not federal agency, has the power to regulate technology. Answer B. The rule is unconstitutional because it amounts to a regulatory taken under the Fifth Amendment without just compensation. Explanation. The strongest legal argument is that banning facial recognition technology constitutes a regulatory taking under the Fifth Amendment. In Pennsylvania, Company v. Mahon, 1922, the Supreme Court established that government regulations that eliminate the economic viability of a business can be considered a taking requiring compensation. Answer choice is incorrect because facial recognition software is not inherently expressive conduct, and restrictions on its use are more likely to be analyzed under property law than free speech. Answer choice C is incorrect because while privacy is an important interest, a blanket ban on an entire technology without compensation raises constitutional concerns. Answer choice D is incorrect because federal agencies do have the power to regulate technology through administrative rulemaking. Question 11. As legal professionals attempt to navigate uncharted territory in constitutional law, a state legislature passes a law making it illegal to publish false or misleading information about elections. A journalist challenges the law, arguing it violates the First Amendment. What is the most relevant legal precedent for this case? A New York Times Company v. Sullivan, 1964, which established that public officials must prove actual malice in defamation cases. B. Brandenburg v. Ohio, 1969, which ruled that speech can only be restricted if it incites imminent lawless action. C. United States v. Alvarez, 2012, which held that even false statements are protected under the First Amendment unless they cause direct harm. D. Schenck v. United States, 1919, which allowed restrictions on speech that posed a clear and present danger. Answer C. United States v. Alvarez, 2012, which held that even false statements are protected under the First Amendment unless they cause direct harm. Explanation: the Supreme Court's decision in United States v. Alvarez, 2012, struck down a federal law criminalizing false statements about military honors, emphasizing that even false speech is generally protected under the First Amendment unless it falls into an unprotected category such as fraud or defamation. While election misinformation is a concern, laws banning false or misleading statements must be narrowly tailored to avoid suppressing lawful speech. Vague and overly broad laws are constitutional because they allow the government to arbitrarily decide what qualifies as misleading. Answer choice is incorrect because New York Times Company v. Sullivan deals with defamation, which is different from a broad law criminalizing falsehoods. Answer choice B is incorrect because Brandenburg applies to speech inciting violence, not general false statements. Answer choice D is incorrect because Schenck's clear and present danger test has largely been replaced by stricter First Amendment protections. Question 12. When a policy change presents unforeseen legal challenges, a state enacts a new law requiring all bookstores to report customer purchases of politically sensitive books to the state government. A bookstore owner challenges the law in court. What is the strongest constitutional argument against the law? A. The law violates the First Amendment because it discourages free expression by subjecting readers to government surveillance. B. The law is unconstitutional under the Commerce Clause because it interferes with interstate book sales. C. The law is constitutional because it does not prevent anyone from actually buying books. D. The law is constitutional if it serves a compelling government interest, such as national security. Answer A. The law violates the First Amendment because it discourages free expression by subjecting readers to government surveillance. Explanation: the First Amendment protects the right to receive information anonymously. In Lamont v. Postmaster General, 1965, the Supreme Court ruled that government monitoring of reading habits discourages free expression and is unconstitutional. Compelled disclosure of book purchases creates a chilling effect. People may avoid buying books on controversial topics out of fear that the government is tracking them. Answer choice B is incorrect because the Commerce Clause is not the primary issue here. The law primarily affects free speech rights. Answer choice C is incorrect because even indirect burdens on speech can be unconstitutional. Answer choice D is incorrect because compelling interest alone is not enough. The law must also be narrowly tailored. Question 13. In an era where artificial intelligence is increasingly used to make employment decisions, a company implements an AI hiring system that automatically screens out candidates who attended certain universities, arguing that these schools produce less qualified graduates. A candidate sues under federal anti-discrimination laws. What is the strongest legal argument against the company's policy? A. The policy violates Title IX of the Civil Rights Act because it disproportionately affects minority applicants from historically black colleges and universities HBCUS. B. The policy is unconstitutional because it infringes on the First Amendment rights of the applicants. C. The policy is legal because companies have the right to choose employees based on educational background. D. The policy is unconstitutional under the Equal Protection Clause because it treats applicants unequally. Answer A. The policy violates Title Roman of the Civil Rights Act because it disproportionately affects minority applicants from historically black colleges and universities. HB Cuss. Explanation. The strongest legal argument is that Title Roman of the Civil Rights Act 1964 prohibits employment practices that have a disparate impact on protected groups, even if there is no discriminatory intent, while employers can educational background as a hiring criterion if the policy disproportionately affects a protected class, such as race or ethnicity, without a valid business necessity. It is unlawful. Courts have ruled that even neutral employment policies can violate Title Omen and they create systemic barriers to employment. Answer choice B is incorrect because the First Amendment protects speech but does not guarantee employment. Answer choice C is incorrect because while employers could consider education, they cannot do so in a way that indirectly discriminates against protected groups. Answer choice D is incorrect because the Equal Protection Clause applies to government actions, not private employers. Question 14. As courts struggle to interpret evolving technology laws, a state passes a regulation requiring all internet service providers (ISPs) to block websites containing offensive content. The law is challenged in court. What is the most relevant constitutional issue in this case? A. The law violates the First Amendment because offensive is too vague and restricts free speech. B. The law is constitutional because states have the right to regulate internet service providers within their borders. C. The law is unconstitutional under the Dormant Commerce Clause because internet regulation is a federal issue. D. The law is constitutional if the blocked content is deemed harmful to minors. Answer A. The law violates the First Amendment because offensive is too vague and restricts free speech. Explanation. Laws that restrict speech must be precise. Vague laws violate the First Amendment because they fail to give clear notice of what is prohibited. In Reno v. Clue, 1997, the Supreme Court struck down a law that attempted to regulate indecent online content, ruling that the term was too vague and overly broad. Answer choice B is incorrect because states cannot impose broad speech restrictions on the internet, which is inherently interstate in nature. Answer choice C is incorrect because while the Dormant Commerce Clause limits state regulations affecting national commerce, the primary issue here is the First Amendment. Answer choice D is incorrect because even child protection laws must be narrowly tailored. See Ashcroft v. Free Speech Coalition, 2002. Question 15. Faced with conflicting legal precedents, a lower court must decide whether state law banning certain types of political protests is constitutional. Which of the following is the most appropriate legal precedent to consider? A. Tinker v. Des Moines 1969, which held that students do not lose their free speech rights in schools. B. Texas v. Johnson 1989, which ruled that burning the American flag is protected speech. C. Citizens United v. Feck 2010, which upheld corporate political spending as free speech. D. Brandenburg v. Ohio 1969, which held that speech can only be restricted if it incites in or section. Answer D. Brandenburg v. Ohio 1969, which held that speech can only be restricted if it incites imminent lawless action. Explanation. The Brandenburg test is the most relevant precedent when deciding whether political protests can be lawfully restricted. Under Brandenburg v. Ohio 1969, speech can only be limited if it incites imminent lawless action and is likely to produce such action. Answer choice is incorrect because Tinker v. Des Moines deals with student speech, not political protests. Answer choice B is incorrect because Texas v. Johnson applies specifically to symbolic speech, flag burning. Answer choice C is incorrect because Citizens United v. Feck focuses on campaign finance, not direct speech restrictions. Question 16. As legislators consider updating existing legal frameworks, Congress proposes a law making it illegal for journalists to publish leaked government documents. A major news organization challenges the law. What is the most relevant legal precedent? A. Nivy, Minnesota, 1931, which ruled that prior restraints on publication are unconstitutional. B. New York Times Company v. United States, 1971, which held that the government cannot prevent the press from publishing classified information. C. Hazelwood v. Kuhlmeier, 1988, which allowed schools to censor student newspapers. D. Gertz v. Robert Welch, Inc., 1974, which defamation of public figures. Answer B. New York Times Company v. United States, 1971, which held that the government cannot prevent the press from publishing classified information. Explanation: the Pentagon Papers case, New York Times Company v. United States, 1971, ruled that government attempts to prevent publication of classified materials violate the First Amendment unless there is an immediate direct threat to national security. Answer choice is incorrect because v. Minnesota deals with prior restraints on state-level publications but does not specifically address national security issues. Answer choice C is incorrect because Hazelwood v. Kuhlmeier applies to student journalism, not professional news organizations. Answer choice D is incorrect because Gertz v. Welch's a defamation case, not a press freedom case. Question 17. When a federal policy contradicts state law, how should courts resolve the conflict under the Supremacy Clause? A. Federal law prevails if Congress has legislated in an area of national concern. B. State law prevails if it was enacted before the federal policy. C. The policy must be negotiated between state and federal governments. D. Courts should balance the interests of both governments and choose the more reasonable law. Answer A. Federal law prevails if Congress has legislated in an area of national concern. Explanation: under the Supremacy Clause, Article Romans Clause 2, federal law overrides conflicting state laws when Congress legislates on a matter of national concern, as seen in McCulloch v. Maryland, 1819. Answer choice B is incorrect because federal law applies regardless of when state law was enacted. Answer choice C is incorrect because states do not need to negotiate if federal law clearly preempts state law. Answer choice D is incorrect because courts do not weigh the reasonableness of laws as they follow constitutional precedents. Question 18. As courts attempt to define the limits of executive power, a president issues an executive order overriding a federal law. Under what circumstances would this be constitutional? A. If the executive order is based on national security concerns. B. If the executive order enforces rather than contradicts federal law. C. If Congress does not explicitly reject the order. D. If the order is in the best interest of the nation. Answer B. If the executive order enforces rather than contradicts federal law. Explanation: presidents cannot override federal law but can issue executive orders to enforce existing laws. Yun Sound Sheet and 2 Bumpany v. Sawyer, 1952. Answer choice is incorrect because even national security concerns cannot override federal law without congressional authorization. Answer choice C is incorrect because Congress does not need to explicitly reject an order for it to be unconstitutional. Answer choice D is incorrect because the Constitution, not national interest, determines legality. Question 19. In a large organization where multiple departments need to coordinate efforts, a company introduces a new cross-functional collaboration platform. However, some departments resist using it, citing concerns about data security and efficiency. What is the most effective strategy to ensure adoption while addressing these concerns? A. Mandate the use of the platform and penalize departments that fail to comply. B. Conduct training sessions while gathering feedback to address security and workflow concerns. C. Allow each department to use its own preferred system to prevent disruption. D. Launch the platform without modification and address concerns later based on usage data. Answer B. Conduct training sessions while gathering feedback to address security and workflow concerns. Explanation: a major factor in technology adoption within organizations is user buy-in. If employees do not feel comfortable with a new system due to security or efficiency concerns, they are less likely to adopt it. Conducting training sessions while gathering feedback allows organizations to adjust policies based on actual user need, reinforcing proper use of the platform. Answer is incorrect because forcing adoption without addressing concerns could lead to resistance. Answer C is incorrect because allowing separate systems would undermine standardization, leading to inefficiencies. Answer D is incorrect because implementing a system without addressing concerns first can result in low engagement and workarounds. Question 20. During a comprehensive review of a process that needs improvement, a company identifies a bottleneck in production that causes frequent delays. Which approach is most effective in ensuring long-term efficiency? A. Increase the workforce in the affected area to speed up production. B. Redesign the workflow by identifying alternative methods to streamline tasks. C. Maintain the current workflow but introduce overtime policies to manage delays. D. Focus on short-term fixes while considering long-term improvements later. Answer B. Redesign the workflow by identifying alternative methods to streamline tasks. Explanation. To eliminate bottlenecks, the most effective approach is to redesign workflows by optimizing processes. Increasing workforce or extending hours may temporarily address issues, but long-term efficiency requires identifying root causes and restructuring tasks. Answer is incorrect because adding workers does not necessarily address inefficiencies. Answer C is incorrect because overtime is costly and does not address systemic inefficiencies. Answer D is incorrect because postponing long-term improvements may allow issues to persist or worsen. Question 21. When dealing with a complex system that shows occasional failures, an engineering team investigates whether the root cause is hardware failure, software instability, or environmental factors. What is the best approach to systematically identify the issue? A. Replace hardware components first to rule out physical defects. B. Implement a structured diagnostic process that isolates variables and tests each component. C. Assume software is the cause since it is most frequently updated. D. Monitor the system for an extended period without intervention to gather more failure data. Answer B. Implement a structured diagnostic process that isolates variables and tests each component. Explanation. A structured diagnostic process ensures that each potential factor is systematically tested, helping narrow down the root cause without unnecessary costs. Answer is incorrect because replacing hardware first may be costly and unnecessary. Answer C is incorrect because assuming software is at fault may overlook external factors. Answer D is incorrect because waiting too long without testing possible solutions could lead to operational disruptions. Question 22. In a high-stakes environment where multiple challenges must be managed simultaneously, a project manager must decide how to prioritize urgent versus long-term goals. Which strategy is most effective? A. Address urgent issues first and defer long-term goals until emergencies are resolved. B. Develop a balanced plan that allocates resources to both immediate and long-term objectives. C. Focus only on long-term goals to prevent frequent reactive decision-making. D. Assign all urgent issues to a dedicated crisis response team while focusing on strategy. Answer B. Develop a balanced plan that allocates resources to both immediate and long-term objectives. Explanation. Balancing short-term crisis management with long-term strategy prevents reactive decision-making from derailing progress while ensuring that urgent challenges are still managed effectively. Answer is incorrect because deferring long-term goals leads to instability and inefficiency. Answer C is incorrect because ignoring urgent issues creates immediate risks. Answer D is incorrect because delegation alone does not ensure a coordinated strategic approach. Question 23. While investigating a complicated issue between different teams, an executive notices frequent miscommunication and project delays. What is the most effective way to resolve the issue? A. Implement stricter deadlines to encourage teams to work faster. B. Establish a shared communication platform and clarify expectations. C. Hold disciplinary meetings for teams that fail to meet project goals. D. Assign one team to oversee all communication to reduce conflicts. Answer B. Establish a shared communication platform and clarify expectations. Explanation. Miscommunication across teams often leads to inefficiencies, and a centralized communication system with clear expectations helps create alignment and improves efficiency. Answer is incorrect because imposing strict deadlines does not resolve underlying communication gaps. Answer C is incorrect because punishment does not address systemic collaboration issues. Answer D is incorrect because relying on one team for communication may create bottlenecks. Question 24. When implementing new protocols in a shared environment, how can leaders ensure compliance while minimizing resistance? A. Provide thorough training and involve stakeholders in the decision-making process. B. Strictly enforce compliance without exception to ensure uniformity. C. Allow different teams to interpret and modify protocols as needed. D. Delay implementation until all employees fully agree with the changes. Answer A. Provide thorough training and involve stakeholders in the decision-making process. Explanation, involvement, and training ensure that employees understand the purpose of new protocols and feel included in the process, reducing resistance. Answer B is incorrect because strict enforcement without flexibility may create pushback. Answer C is incorrect because inconsistent application leads to fragmentation. Answer D is incorrect because waiting for full agreement can delay necessary improvements. Question 25. During an emergency response where multiple areas are impacted, what is the best way to coordinate efforts and minimize disruptions? A. Centralized decision-making. 2. A single response team. B. Establish a communication protocol that ensures real-time updates across all affected areas. C. Focus response efforts on the most visible impact areas first. D. Allow each affected area to handle its response independently. Answer: B. Establish a communication protocol that ensures real-time updates across all affected areas. Explanation: real-time coordination prevents confusion and allows efficient resource distribution to areas most in need. Answer is incorrect because overly centralized control may slow response times. Answer C is incorrect because focusing only on visible areas may neglect critical underlying issues. Answer D is incorrect because an uncoordinated response leads to inefficiency. Question 26. In a situation where formal requirements conflict with practical constraints, how should a project manager balance compliance and efficiency? A. Strictly adhere to formal requirements regardless of project delays. B. Find innovative solutions that satisfy compliance while optimizing efficiency. C. Prioritize practical constraints and adjust formal requirements as needed. D. Implement a temporary workaround and revisit compliance later. Answer: B. Find innovative solutions that satisfy compliance while optimizing efficiency. Explanation: when formal requirements conflict with practical execution, the best approach is to find innovative solutions that meet compliance standards without sacrificing efficiency. Answer is incorrect because rigid adherence may cause delays and inefficiencies. Answer C is incorrect because ignoring compliance can result in legal and operational risks. Answer D is incorrect because temporary workarounds can lead to long-term compliance violations. Question 27. While analyzing the root causes of sequential problems in a production line, engineers find that multiple failures stem from a single underlying issue. What is the best approach to prevent recurring problems? A. Address the most visible failures first and monitor improvements. B. Conduct a root cause analysis to eliminate the underlying issue. C. Increase routine maintenance schedules to minimize failures. D. Implement additional safety checks at each failure point. Answer: B. Conduct a root cause analysis to eliminate the underlying issue. Explanation: root cause analysis ensures that engineers are addressing the fundamental problem, preventing recurring failures rather than just treating symptoms. The answer is incorrect because focusing only on visible failures does not address systemic issues. Answer C is incorrect because maintenance alone cannot fix design flaws. Answer D is incorrect because additional checks may slow production without solving the root issue. Question 28. During a major transformation where existing methods are being replaced, employees express resistance due to uncertainty about new workflows. What is the best way to ensure a smooth transition? A. Gradually phase in changes while providing continuous support and training. B. Implement all changes at once to minimize prolonged disruptions. C. Mandate compliance with new workflows without extensive explanation. D. Allow employees to choose between old and new methods during transition. Answer A. Gradually phase in changes while providing continuous support and training. Explanation: change management strategies show that gradual implementation combined with support and training reduces employee resistance and ensures smoother adaptation. Answer B is incorrect because rapid changes without preparation can overwhelm employees. Answer C is incorrect because forcing compliance may lead to low morale and inefficiency. Answer D is incorrect because inconsistency in methods can lead to confusion and operational inefficiencies. Question 29. When developing a solution that must address opposing needs between two departments, how should leadership proceed to create a balanced outcome? A. Prioritize the department with the highest operational impact. B. Find a compromise that meets both departments' core requirements. C. Allow each department to proceed with separate solutions. D. Assign a neutral third party to dictate the final decision. Answer B. Find a compromise that meets both departments' core requirements. Explanation: a balanced compromise ensures that both departments' critical needs are met while minimizing conflicts and maintaining operational efficiency. Answer is incorrect because favoring one department creates long-term friction. Answer C is incorrect because separate solutions can create inefficiencies. Answer D is incorrect because external decisions may not align with internal priorities. Question 30. In a multi-location scenario where consistency requirements must be upheld, a company finds that performance standards vary significantly across branches. What is the most effective way to establish uniformity? A. Enforce a strict set of rules across all locations without flexibility. B. Develop standardized procedures while allowing for minor local adaptations. C. Provide incentives to top-performing locations and encourage others to follow. D. Assign centralized oversight to a single branch to monitor compliance. Answer: B. Develop standardized procedures while allowing for minor local adaptations. Explanation: standardizing procedures while allowing some flexibility ensures that operational consistency is maintained while accommodating local challenges. Answer is incorrect because rigid enforcement ignores regional differences. Answer C is incorrect because incentives alone do not ensure uniformity. Answer D is incorrect because centralized oversight may not account for unique local conditions.